question from the Modern Divorce Support Group. Stepmom here. My husband has the case where his ex-wife took the kids and moved out of the state. She claims because she has decision-making and primary custody, she did not need dad's permission to move 1,700 miles away. Dad had a meaningful relationship with the kids. He saw them a few times a month at mom's discretion. He has a text where she said, I have decision-making, so I have boundary conditions. And for the time that you spend with them, he had them for Father's Day, and then the next day they moved, and Dad was never notified by Mom. The kids told Dad that they were leaving. Dad has kept up with the kids by FaceTime calls and texting. He was told by an attorney during a consultation that he could file for emergency custody, but he didn't want to add stress to the kids. So he filed for a modification and asked for all school breaks and summer breaks, a long-distance plan. Mom has obtained a lawyer and objected to the long-distance plan, stating the lives they have built in the new state shall not be disrupted. I can't believe a lawyer would write that. She's claiming now that the father has been barely active in the kid's life, which can be proven false. And he filed a proposal stating that she filed a proposal saying he can have FaceTime calls and texts with the kids. If he wants visitation, he can come to the new state. The judge has ordered they go to mediation before their next court date in March. My husband wants a long-distance plan and joint decision-making. He pays child support. He has done everything Mom has asked him to do. He has missed plays, recitals, football games, soccer games, and so much more with the kids. How likely is it that he will have a long-distance parenting plan be granted? It's been 7 months since he's seen them in person, and it's killing him. He was planning to go to their new state over Christmas, but Mom made it clear to not show up at the house. Hello, Billy Tarasio, Arizona family law attorney. I have questions. Why was Dad's previous parenting time a couple times a month at Mom's discretion? That's a bizarre parenting plan. And there's probably a history here that would make a difference to my answer. That's why I point that out first. Now, generally speaking, you cannot move out of state without the court's permission or the other parent's permission if you have joint legal decision-making here in the state of Arizona. If you have sole legal decision-making, there are certain conditions where you can move out of state without the court's permission or the other parent's permission, but you cannot impede the other parent's parenting time. So in the case where somebody has sole legal decision-making and the other parent has no parenting time, or that parenting time is entirely at that other parent's discretion, then you may be able to move out of state, check the statute, check with the lawyer, without the permission of the judge or the other parent. In this particular case, I understand that Dad didn't want to disrupt the kids' lives, but you have to enforce the court order. If somebody goes and moves your kids out of state, that's a blatant contempt, and you need some sort of temporary parenting time. So you could have filed for a temporary parenting time and gotten that Christmas parenting time that you were talking about. So a lot of unanswered questions for me on this one. What do you all think?